time is 9:01. My name is Christian Waugh, and I hereby call this Citrus County Code Compliance hearing to order. I'd like to now ask you if you join me for the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
If any person decides to appeal the decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
So, ladies and gentlemen, we usually follow an agenda for these hearings, and the next item on the agenda is to approve the minutes from April 20th, 2022. So I'd like to ask if there are any objections or proposed modifications to the minutes as are currently formulated. I hear none, and I have none on my own, so I approve the minutes.
Staff update, abated, and continued cases listed out front.
Okay. All right. Ladies and gentlemen, again, good morning. My name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but all it means is that Citrus County has hired me to preside over your hearing. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, and that may include evidence if you wish. During this process, the county attorney's office or myself may have questions of parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak on each case, and if there are, such members of the public will have an opportunity to speak. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. It is not an appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before any fine begins to accrue. You must abate the violation by that date, that is, fix the violation, or the fine will continue to accrue for each day that you're in violation. The law then allows Citrus County to impose that fine as a lien on all of your real or personal property, and the county may foreclose on that lien or seek a money judgment against you after that lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the law. The county will continue filing liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I will impose all costs required by the county ordinance or regulation. If you abate or fix the violation in the time provided, then that cost will remain minimal. But if you don't timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you'll be required to return on another date. In the time between the hearings, I will require that you comply with the county and its laws in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each and every day of the violation from today's date forward. Your failure to return on the next date may be deemed evidence of a failure to cooperate with the county. I don't think we're here on an appeal for any order. You do have the right to appeal any order that I make today, as may be provided by law. Thank you for your attention.
First case today, Sabra and Portwood, case number 215-9794. Code officer on the case, Alan Jonason, page 14 of your agenda.
Ms. Portwood, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record, ma'am.
Safer and Portwood.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 215-9794, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 3255 East Deal Street, Inverness, Florida. Property owner is Portwood Sabra Ann. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 4 March 2022, a compliance inspection on April 8, 2022, and photos of my final inspection conducted on 17 May 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Ma'am, I'd like to ask you to take a look at what he's just identified and take your time in doing it, but let me know if you have any objection to those being evidence in this hearing.
It's not there now.
Ma'am, do you have any objection to these
No.
documents being evidence? Okay. Is there anyone from the public who's going to want to be heard on this case? Okay. Then without objection, what's been proposed as exhibits A and B are evidence. Please proceed.
On 4 March 2022, I conducted an initial inspection and observed the property to be in violation. On 4 March 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 8 April 2022, I conducted a compliance inspection and observed that the property remained in violation. As of my final inspection on 17 May 2022, the property remains in violation.
In your estimation, has there been improvement over time?
There was, and then it backtracked and
Yeah, the refrigerator and the stove went out this week.
Well,
So
it-
they're sitting out front.
it looks like
Y'all
there's
can't
been-
give me 2 days to move them.
Well, it looks like there's been improvement to me, but I'm curious. So initially, it appears that there were a couple different things that were putting the property into violation.
there's tree debris in the back of the yard. There's tires without rims out there. There was yesterday. I don't know if they're still there or not.
It was one
Appliances.
tire that was a tire swing that a tree fell in my backyard.
Well, it looks like the lawn was improved. It looks like some of the lawn debris, but Mr. Jonathan was speaking. So
Sorry.
you had a couple other, were you done?
I was, yeah.
Oh, okay.
Yes, sir.
I do see the tire and the stove, and ma'am, you said the stove is gone? Or the oven?
They are under the carport.
It's not going to be good enough under the code, but Mr. Jonathan, I'm looking at page 11 of 12, Exhibit A, and it looks like there's a grill.
Are you not allowed to have anything under your
Well, we'll get into that.
carport?
So, is this everything in this photo a violation?
Whatever this is, I think it's.
Looks like a grill.
tarp, but I think this is a tarp or
Oh,
something.
okay.
I'm not for sure. And then they've got household trash
Right.
out here and some other debris.
It's
out
not
there.
in an enclosed receptacle
Yes,
or
sir.
anything. Okay. We'll talk
No.
about that. But let me also ask you about page 12. There's some appliances. I don't know if they're usable or not. They look okay from where I'm sitting, but
Yes,
they're functional.
yes, it's only the refrigerator that's not, which I will take it with me when I go back on Thursday.
I think
We
the
just
moral
stuck it out this week. Cause you can tell from the pictures it wasn't out there.
Well, I think the moral of the story, though, Ms. Portwood, is that, this is a violation of Section 20-31A, and so when you have junk and debris in the yard, but it's not enclosed in an acceptable receptacle or container, then it's a violation of the code. And so that's why I was kind of going through all the different things. It's not good enough to stack everything under a covering, because that's not good enough. It's not enclosed when you just have a roof over it. Part of being enclosed is that you can't see it from the street, and it's enclosed in between with a bunch of walls. Does that all make sense? No?
Slightly. That is our work area. Are we not allowed to have tools and stuff out there that we're working on?
Strewn across the yard?
No, just under the carport. There's absolutely nothing in that front yard.
Well,
This morning, I have my pictures in my phone. There's absolutely nothing in there. The only thing, there was a tree that fell in the backyard. I don't know if I put a time limitation on getting rid of it. The only thing that is left of it is the main trunk.
well, let me show. I don't know if you can see it from here, but page 11 shows the grill here, and what purports to be a tarp, perhaps, or maybe it's a cover for the grill. I don't know. And then there's basically trash.
Yes,
Okay, is the trash all gone?
yes. If you want to see pictures, which I know
All
you
right.
can take my phone to evidence, you have to.
When did you get rid of it? Because this photo's from yesterday.
Yesterday evening.
Okay.
We pushed everything wherever, you know.
What do you mean pushed wherever? That could mean a lot of things.
Are you not allowed to have a washer and dryer under your carport in the area? Does it need to be completely tarped in? Like,
Well, ma'am, I can't look at the photos on your phone unless you're gonna introduce the phone into evidence.
that's fine. How long we
No, we're forever. So I don't want to take your phone.
Or just ask the question.
No, ma'am, I can't look at the photos on your phone because that'd be evidence. So, Mr. Jonathan, what
Are
has
we not
to?
even allowed to have a grill outside unless
Well,
it's covered?
let me ask Mr. Jonathan. So, what has to be done on this property to bring it into compliance from your perspective?
So any of the junk and the debris has to be in an enclosed area or taken to a landfill. The tree debris has to be gone, removed, burned, whatever. The tires without rims have to be removed. Other than that,
Well, she's asking a more difficult question now, and that is, what about the appliances? Is she allowed to have appliances out in the carport?
No.
Well, there's
sir.
an extra washer and dryer because my son's keeping it there while he's having his place built. We already have 2 sets in the house, and we'll move the 3rd set inside.
no,
Or do
sir.
I need to move it around back into the back porch?
If the appliance is in operating condition and is connected the way it's supposed to be, then it can be there. But if it's just sitting there, it cannot be there.
All right, so let me read the definition of junk here. It says, junk shall mean any abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, or used and non-functional tools, equipment, and implements. The way I read it is that if you are just keeping appliances out there that are not being used, then that probably is a violation if it's not contained within some
But
kind
it's
of
functional.
right. It may be functional, but it
Grill's
can't
not
just.
being used unless you got
Well,
fire
that's to
maybe.
that's to stop there being a junkyard. Theoretically, you could have 30 of those things, right? And they may be usable, but they're not being used,
Right.
and so the code prohibits that. I don't know why, but the code says what it says. So you're being asked to clean it up,
Right.
basically. How much time would you need to just clean all that
So
up?
does a tarp stretched over that side and you can't see it abate the issue?
Does it, Mr. Jonathan?
No, sir.
Why?
It's not in an enclosed building.
Okay, so if you read this code section, let me read what the violation.
They make buildings out of
I
vinyl.
want you to understand what the violation is. It says, it shall be unlawful for the owner or tenant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except for junk enclosed in leader receptacles or completely enclosed buildings. That's why a tarp isn't good enough, because that's not a completely enclosed building. It's not an enclosed litter receptacle.
So our work table, our grinders,
And hold
our
on a second.
stuff-
Now there's another exception. Junk which will not fit into standard litter receptacles and which is set out for no more than 48 hours for pickup. So that answers your question about the time limit. If you have stuff out there for trash, it's got to be, you've got 48 hours. Recyclable materials stored in receptacles, provided that it's for recycling, and junk stored in a lawfully established and maintained junkyard, garbage, or waste disposal site. So I hope that answers your questions. I mean, you've just got to clean this up.
Mhm. I'm just confused as to whether or not we can even have our workbench out there, our grinders out there, our tools out there.
A workbench doesn't seem to violate the definition of junk.
Yes, the
Because
neighbors do
it's not
like it.
abandoned property, it's not debris, litter, waste materials. Does a workbench constitute a violation of the code?
It does
Mr.
not,
Jones?
sir.
Okay, so that answers your question. What else?
The only other question.
We're talking about the debris,
All that stuff is gone, so I don't care about it.
well, we care. We want to make sure that the law's clear and
Right.
and that you know what you have to do to fix it. So you heard what Mr. Jonasson said. How long will it take you to clean everything up?
Give me a week.
I can give you 30 days. Does that work?
I don't want to drag it out, really.
Well, I know, but I'm not going to give you a week because that's too short a time in my opinion.
All right,
but
fine, 30
Willow-
days then.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to the violation. We would also ask the Special Master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
All right, I mean, I'm going to find that the property is in violation, but I'm going to grant you 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine would be recorded and would constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and you would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record. Ms. Porwood, I think you need to clean it up, get in touch with the county when you think you've done it. Earlier is better in case there's any questions, because if there's still any doubt, they can come out there and talk to you about it, okay? All right, thank you.
Thank you, sir.
Thank you.
Next case, Rex A. Durbin, case number 216-2094. Code officer on the case, Amy Becker, page 5 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your name, sir?
Rex Durbin.
Thank you.
Good morning.
Good morning.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 216-2094, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 4239 North Citrus Avenue, Crystal River. The property owner is Rex A. Durbin. I have good service via posting of the property as well as the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on April 7th, 2022. Photos taken on April 28th at my corrective action inspection. Photos taken on May 4th showing the posting of the property. And photos taken on my final inspection, May 17th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Sir, I'd like to ask you to take a look at these documents, take your time in doing so, and let me know if you have any objection to them being exhibits in this case.
No, sir.
Or evidence in this case.
I am guilty.
Well, I'll let you look through the evidence at the very least and just let me know if you object to anything. Mr. Durbin, do you have any objections to this evidence?
No, sir.
Okay. You indicated you're guilty. I guess.
I don't know what else to say.
Well, I take it that you're not contesting that there's, I guess, miscellaneous junk and debris in the yard?
Yes, sir.
All right. I mean, assuming that, that's true, if I look at the evidence and if I agree, then how much time would you need to fix
If
it?
I could get some 90 days,
90?
yes, sir.
Okay.
If I could, that would be very
All right.
a profit with me.
What's the county's recommendation?
The county's recommendation is, first of all, I just want to say there's been significant improvement.
Okay, great.
Significant.
Thank
So
you.
I'm very proud of him. He's done a lot of work, just a little ways to go. The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Is there anyone from the public who's going to want to be heard on this case? Well, I'm not going to drag it out. Mr. Durbin, you're not contesting it. I'm going to admit these documents into evidence, Exhibits A and B. I'll adopt the county's proposed findings of fact, and in recognition, I also see great improvement through the photos. I'll find that the property's in violation. Mr. Durbin, I'll give you 90 days from today to abate the violation.
Okay.
If the violation is not run in compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and would constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date that it's first recorded. And Mr. Durbin, you would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Do you have any questions?
No, sir.
Okay, thank you.
Thank you.
Next case on the agenda, Riverview Mobile Estates Property Owners Association Incorporated. Case number 215-2024. Officer on the case, Matt Hampton. Expert on the case, Joanna Katu.
Did you say 2-4?
Yes, sir.
I'm sorry, what page in the agenda?
I'm sorry, page 15 of your
Okay,
agenda.
thanks.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Good
Morning. Matt Hampton, Citrus County Code Compliance Officer, case number 215-2024, special requirements for all accessory use structures, a violation of Citrus County Land Development Code 3102A. The address is 5715 South Garcia Road, Homosassa, Florida. Property owners, Riverview Mobile Estates Property Owners Association, Inc. Good service via signed certified mail return receipt. I would like to authenticate the documents requested to be admitted into evidence. Exhibit A is photos I took during my initial inspection, October 5th, 2021. Photos I took during my corrective action inspection, March 10th, 2022. Photos I took during my final inspection, May 17th, 2022. Exhibit B is a copy of the property appraiser's report showing a vacant lot, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail return receipt signed for by R. Anderson on March 23rd, 2022 at 9:39 a.m., and a copy of the email requesting a continuance April 14th, 2022.
Is there anyone from the public or from the Property Owners Association who's going to want to be heard on this case? All right, let the record reflect that there's no response.
Is this their property?
Was this continued from the April hearing? Okay.
Yes, sir.
All right. Without objection, what's been proposed as Exhibits A and B are evidence?
I conducted my initial inspection October 5th, 2021, and observed the property to be in violation of the Land Development Code listed above. The property is a vacant parcel and has boat trailers, travel trailers, fifth wheel trailers, and other vehicles being stored on the property. Notice of violation was issued October 26th, 2021. I spoke to Robbie Anderson on November 1st, 2022, and she wanted an explanation of the violation. I advised her to speak with the Land Development Code because there's sometimes avenues in which they can abate it, that don't want to give them any misinformation. The hearing, I conducted corrective action inspection March 10, 2022. There had been no change. Notice a hearing was issued March 17, 2022. On April 14, 2022, I received a request for continuance from the April 20th, 2022 hearing to today's date. As of my final inspection, May 17, 2022, there had been no further attempt that I am aware of to come into compliance. No, one at a time, yeah.
So which one is this one? I'm
This is
sorry.
the 57.
215-2024.
Yeah,
Thank you.
2024. Yes, ma'am.
Sorry. Joining Contee Land Development, it's Coastal Lakes Residential, CLR. RV and boat storage is not allowed there. Are there avenues? Yes. Coastal Lakes Commercial with a master plan, perhaps.
So you're saying that if the Property Owners Association wanted to, they could conceivably rezone?
Correct.
Um,
It's possible. It's not out of the question, but right now it's a residential lot.
Is this a Property Owners Association that just has mobile homes in it? or-
Despite the name, it's across the street from this site, and they're usually site built. It's CLR. It's not CLRMH. It's not a mobile home park, and it's not a mobile home subdivision. It's an old remnant name.
Interesting. So it's actually got built residences in there that are not mobile
Correct.
homes?
Across the street.
Across the street. And so this is this a common area? Do you know?
It appears to be. It's owned by the Property Owners Association. The next lot was their old wastewater treatment plant, but this was a vacant lot that they apparently acquired.
Have you or anyone else from the county had contact from these folks to try and for
I-
them to try and understand what's going on?
Not recently. I can see something from several years ago where they asked how they could do this, but I don't see anything recently.
Were they violated before? I mean, is that what prompted them to inquire?
No, I think they were probably asking how they can do it. That's what the notes appear to say.
All right. Well, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
What I'm concerned with in terms of there's a violation, there's no doubt about that. The only issue is how much time would make sense because we're dealing with a property owner association and it looks like a lot of different people might be storing their stuff there. I'm concerned with the POA's ability to actually, jettison everyone's stuff if there's snowbirds or something like that and they're not around. We're now in May.
They've known since October of last year, and they've really taken no action other than a single phone call to me, and then wasted our time of asking for a continuance. I mean, they've been well aware of it.
I take your point then. So how were they made aware of it in October? Is that when you initially?
When I spoke to Robbie Anderson, who is a representative of the Homeowners Association, she asked me specifically, what is the violation? I explained it to her, told her that they could not be stored there. I told her that there were avenues that they may be able to approach. That's why I directed them to talk to land development to find out what those other avenues were. I have not heard any other communication with the exception of when she asked in April to have a continuance from last month, and other than that, there's been no other further contact.
Well, I accept what you're saying, but the problem is the idea of holding owners responsible for the sins of a property owner association. In other words, all the owners who've stored stuff there may not know. It may be very accurate that the POA has known better, but they may have led their owners down a garden path. I don't know. So what I'll do is I'll find the property in violation. I'll grant the association 120 days from today to abate the violation. If the violation is not brought in compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the POA. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record.
Thank you.
Thanks.
Next case on the agenda, Riverview Mobile Estates Property Owners Association, Inc., case number 215-2025, Code Officer Matt Hampton. Expert on the case, Joanna Coutu, page 16 of the agenda.
Morning again. Matt Hampton, Citrus County Code Compliance Officer, with case number 215-2025, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 5737 South Garcia Road, Homosassa, Florida. Property owner is Riverview Mobile Estates Property Owners Association, Inc. Good service via signed certified mail return receipt. I would like to authenticate the documents requested be admitted into evidence. Exhibit A is photos I took during my initial inspection, October 5th, 2021. Photos I took for my corrective action inspection, March 10th, 2022. And photos I took during my final inspection, May 17th, 2022. Exhibit B is a copy of the property appraiser showing the property to be a sewage, wastewater, or wasteland designation, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail return receipt signed for by R. Anderson, March 23rd, 2022 at 9:39 a.m., and a copy of the email requesting a continuance from the on April 14th, 2022.
Is there anyone from the public or the POA who's going to want to be heard on this case?
It's down the street, right?
No, it's right
Oh, okay, 'cause
It's a fenced-in area.
oh, there's yours. Okay.
Okay, thanks. So this is a different parcel than on the previous case?
It is a different parcel and it's different addressed. However, the two parcels are adjoined and they are fenced in as if they were one parcel, but they are two separate parcels. I conducted my initial inspection October 5th, 2021. I observed the property to be in violation of the land development code listed above. The property is listed as a sewage wasteland parcel and is boat trailers, travel trailers, fifth wheel trailers, and other vehicles being stored on the property. Notice of violation was issued October 26, 2022. I spoke to Robbie Anderson on November 1st, 2022, and she wanted an explanation of the violation. After the explanation, I advised her that there were other avenues that she could go down, but she needed to speak with land development to make sure she had the most accurate information. I conducted a corrective action inspection March 10th, 2022. There has been no change. Notice of hearing was issued March 17th, 2022. And on April 14th, 2022, I received a request for continuance from the April 20th, 2022 hearing to today's date. As of my final inspection, May 17th, 2022, there has been no further attempt that I'm aware of to come into compliance.
Joanna Coutu, Land Development. It's also a CLR designated lot. We have a history on this one. In 2010, they did remove a wastewater treatment plant on the site when Central Sewer came down there. So we have previous development on the site. The wastewater treatment plant is gone. So this one was already improved. Now should be vacant, is no longer.
I guess I'm trying to understand the sewage waste designation.
That's the property appraiser.
Okay.
Sometimes they're reflecting that because of wetlands. There are some wetlands in the area, or they may still be picking up the wastewater treatment plant from
But that's not
15
an
years
issue
ago.
for the purpose of the violation.
Correct. It's their assessment category.
Okay, it just needs to be vacant because it's a CLR. And
Right, and we know something was removed there, so we know absolutely this is vacant and should be vacant.
I'll just make another note that I did make in the last hearing. It looks like Miss Anderson is actually from the property management company, which was retained by the POA, which increases my concern because sometimes they may make mistakes as well. I don't know that. It could be that they're just putting up the middle finger as well. I don't know. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $150 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the Special Master additionally fine it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
Okay, Exhibits A and B are evidence for the record. I adopt the county's proposed findings of fact. The property is found in violation. The property owner is going to be granted 120 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the POA. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of the first recording. And the POA shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Next case, John W. and Joy R. Thompson, case number 2160233. Code officer on the case, J.C. Charlton. Expert on the case, Joanna Katu, page 17 of your agenda. How you doing?
Mr. Thompson? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Thompson.
Thank you, sir.
Good morning, sir.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. Case number 2160233, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address 13010 Baltic Ivy Street, Crystal River, Florida. Property owners John W. and Joy R. Thompson. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 9th of 2022, corrective action inspection on March 30th, and photos of my final inspection on May 17th of 2022. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the signed certified mail return receipt, and a copy of the property appraiser summary listing the property as vacant.
All right, sir. Again, I'd like to ask you to review these documents and let me know if you object to them being evidence in this hearing. Take your time.
Okay. Okay. Road. Yeah. Okay. That's why you can't see it. Okay. Okay. I've got that.
Sir, do you have any objection to these being evidence?
No.
Okay. Is there anyone from the public who's going to want to be heard on this case? Okay. All right, then without objection, what's been proposed as exhibits A and B are evidence.
I conducted my initial inspection on March 9th, of 2022, observed a Connex storage container and debris on the vacant property zone, Coastal Lakes Residential. I've had contact with the property owner, Mr. Thompson. He has stated he wants to work on removing the items from the property. But as of my final inspection on May 17th of 2022, all items remain on the vacant property.
Is there anyone else from the county who wishes to testify?
Joanna Katu, Land Development. It's a coastal lakes and residential designated zoning. It should be vacant. We have no primary structures,
Okay.
no principal structures, excuse me.
Mr. Thompson, what's going on?
Well, the property's out, kind of out in the middle of nowhere, as you can see. You can't even see, you know. We were basically going to store some stuff there, sell our house in Orlando. I live in Orlando, and then build a house there. Well, we found out, I guess we can't store nothing there, so that's kind of where we are now. So what we did, we're going to step up our game, go ahead and build a house now, and which actually, after thinking about it with the economy, our savings are actually, with inflation and everything, our savings is going this way. Building a house makes sense, you know. So I've got my plans that are sent to the engineer, and I was hoping really by today, I was hoping to have plans from the engineer and paperwork from our septic people. But as I'm standing right now, I'm still waiting on the engineer papers.
Okay.
So, but I do have drawings that are, but they're just a drawing, they haven't been stamped yet, they're not approved. So what I'm basically wanting to do is go ahead and put a house there.
That makes sense. Have you submitted anything to the county to pursue this? I mean, I heard what you said about the plans,
But I've
but
talked to the building, I've talked to everybody.
you have? Okay.
You know, basically you can't do anything until you get these plans. And then once I get my engineered plans that are stamped, take them to the septic people, they say they're about 2 weeks out from the time they get their paperwork and do their thing. Then from there, I go to get my building permit. And when I get the building permit, electric and the well people is gonna be my biggest problem.
What'd you say, the well?
Yeah, 'cause they're a little further out. You know, they're waiting, you know.
Oh, I see what you're
trying to
saying.
get somebody over there.
Do you know if you'll have to hook into central utilities or anything, or do you, you're too far?
Well, I will have, the electric will be, but it will be
Sure,
well,
yeah.
septic,
Yeah, you're not gonna use just solar.
No.
Okay. Does obtaining a building permit abate the violation?
No, not just the.
You have to have the actual structure on the property.
Yeah, yeah, unfortunately, the stuff needs to be removed, and then once he establishes a residence there, the CO, then he can get a permit for the Connex if he wants to put that back.
Is part of the building.
Oh, you're gonna use that as part of your building?
It's
Okay.
actually gonna be 3 of them altogether.
Okay, well,
It's only the first.
get the building permit issued then, and if that's actually part of construction equipment, a little different.
Okay, in other words, you're saying the stuff that's on the property, including the connects, is going to be a part of the principal structure?
Except for you can't see it in the pictures, but I do have a canoe and a boat there that apparently to your paperwork is junk.
Well,
Yeah. But besides that, and I would like to have permission to leave my boat and canoe there while we're building.
I won't be making a finding that the canoe is junk today. It's irrelevant to the violation here, but I think, I want to make sure I understand what you're saying. So the connects is actually going to be a part of the principal structure?
Yeah,
Okay. How?
yeah,
It's going to be converted?
yeah. Well, it's actually, yeah, it's basically gonna be another one sitting next to it, with
Mhm.
another one actually sitting this way,
Okay.
you know.
All right. Well, here, what's the county's
Like I
recommendation?
said, this was my plan, but it wasn't supposed to happen now. I was actually gonna do it after my wife retires, which is,
Oh, I understand.
actually, she's getting ready to retire and then within the next year. So,
All right.
so we were planning on letting everything just sort of sit, and then I guess we found out we couldn't, so here we are, yeah.
I hear what you're saying. What's the county's recommendation?
Citrus County Code Compliance Division respect for request special master assessed a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
So, Mr. Thompson, you heard me ask a question about whether or not pulling the building permit actually remedies the violation. And initially usually the answer is no. But it may be that the answer is yes, depending on if the plans you submit and what you get approved for actually integrates the stuff that is on the property. Is that right?
And I hope within 90 days,
Excuse
I
me.
have it built.
Won't help the canoe, kayak, the other stuff sitting around, but it will do the Connex container. If he's
It
going,
won't help the canoe
right.
because it's still storage of a canoe?
Right, unless,
Okay.
unless it's a construction material, right, you still have storage there.
So this is the conversation we just had, does that make sense to you, Mr. Thompson? It's not that the canoe's junk, it's that you're not allowed to store things on that property unless you've got a principal structure there, or the building permit integrates, and your plans integrate the stuff that's on the property. It's hard to see how a canoe will be a part of making your principal structure.
They get like ornament out front or something.
Well, so the issue here is how much time do you think you're going to need to pull the permit?
Well, the GC told us we'd do it in less than 90 days, but I've been waiting 30 days for the engineer, so.
Yeah.
You know, you're, I don't
Well, what I'm going to
I have a
do,
phone number you can call, yeah.
oh, I don't need to call anybody, but
Cause that's about all I can tell you too. He actually, cause I told him, I called him yesterday and told him I was coming here today, and he says he thinks, but of course, when he said it, he says, well, yeah, that's how it goes. He said a week, we'll have it.
Mr. Thompson, you have some documents with you. You held them up to me. Are they copies of anything, or are
It's
they?
actually was submitted to the engineer.
Are these copies, or are these originals?
Copies. No, they're copies.
Would you
I'm waiting.
mind introducing them
Yeah, oh yeah,
so that I can review them?
sure, yeah. The picture
You're not going to get these back. I want to be clear. You're not getting these back.
That's fine.
Okay.
That's fine. The picture there is not, that's his idea of the outside look. It's,
For the county to understand, the reason why I want to see these is because they will influence the amount of time I give
yeah.
to remedy the
Well,
violation.
check it out. Actually, it's kind of neat. It's 3-bedroom, 2-bath. Neat little place, yeah. Wasn't exactly what I wanted to do a year or so from now after we sell our house over there, but hey. And then after, like I said, I got thinking about it, and really with inflation and everything, it might actually be a better best thing for me to do. Go ahead and move on it now and get it built, you know?
Is there any objection from the county, these being evidence for the respondent?
No objection.
Okay. Let me just take a look at these.
Check that out. Like I said, that dry outside picture is not, you can't really judge, but the inside stuff is what exactly will be. The outside be more of a wraparound porch probably kind of thing.
Yeah, I mean, these look like legitimate and recently dated plans.
Yeah, this guy's actually built quite a few of these things, actually.
Okay, what I'm going to do is I'm going to find that the property is in violation, but Mr. Thompson, I'll grant you 120 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day is going to start on the property. The fine will be recorded and will constitute a lien on the real or personal property that you own, and that Miss Thompson also owns. You guys are the property owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and Thompson's will be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Okay?
So at 120 days.
120 days.
We're halfway through building this. Where we
It
stand.
depends. Again, so if you
Let's
have
say it's
pulled,
all there.
hold on a second, if you have pulled a permit that integrates the materials that you still have on the property, it's not gonna be a violation. So if you're halfway through, you're okay. You just have to have the permit that integrates the stuff. Now, if your permit does not integrate the stuff that you have on the property and you haven't gotten
So
rid
I
of
need
the
to move
stuff,
my canoe and my boat.
and you haven't got rid of the stuff in 120 days, you're in violation,
Yeah.
okay? So
I
the
do-
clock
I
will
can't
start
keep
running,
I can't keep the canoe there,
no,
honestly, if I have it, okay,
all right.
All right.
Thank you.
Thanks.
All right.
Call me.
all right, yeah. Thank you very much.
Thank you, sir.
Next case on the agenda, Scott Linden, case number 2160809. Code officer on the case, J.C. Charlton, page 10 of your agenda.
I see two cases. Are you going to present both at the same time or not?
No, the other two are,
Oh, three?
yeah, yes, they're the other two.
Okay.
are nuisance.
Okay.
Oh, I'm sorry.
Yes,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Scott Linden.
Thank you, sir.
Thank you, sir.
J.C. Charlton, Citrus County Code Compliance Officer, case number 2160809, a violation of Citrus County Land Development Code, Section 3320, B, trucks parked in selected land use districts. The address is 989 North Amelia Earhart Point, Crystal River, Florida. Property owner Scott Linden, good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 17th, 2022, corrective action inspection on April 19th, and my final inspection on May 17th, all of 2022. Exhibit B, notice of violation, notice of hearing, and a copy of the signed certified mail return receipt.
Sir, you've been here for the other hearings.
Yes, sir.
I'd like to ask you to look at these documents and
Sure will.
let me know if you have any objection to them being evidence.
No, I have no objections.
Okay. Is there anyone from the public who's going to want to be heard on this case? All right. All right, then without objection, what's been proposed as exhibits A and B are evidence.
If I may, Your Honor, I know you're not a judge, sorry.
Yeah.
The Mercedes is gone. I told him the car was there, so the Mercedes is gone, so I don't know when you took the picture. But
This is,
I was involved in an accident, and that's why the car was put there, but it was still registered and insured.
Well, Mr. Linden, let me hear from the county first on what they're trying to present.
Oh, okay.
I don't even know what they're presenting against you at this
Well,
point.
I just go by the letters, so.
Well, that's
Okay.
good, but I just need to hear what they're actually going to present against you first.
Okay.
And then I definitely want to hear from you.
Okay.
All right.
on March 17th, 2022, I conducted my initial inspection and observed a detached semi-trailer on the property. I've had contact with the property owner and explained the violation. He stated that the trailer was on the property as part of his building permit. I checked for any open permits on the property. There was a permit applied for but not issued. As of my final inspection on March 18th of 2020, on March 17th, the permit was applied for on March 18th of 2022. As of my final inspection on May 17th of 2022, the detached trailer remains on the property.
Okay, so I just want to make sure I understand what I'm looking at.
Yes, sir.
Before I hear from Mr. Linden. So on page 1, there's a picture of a boat and what looks like a hitch.
Mm-hmm.
And in the top right, there's a red container,
like
it looks
a-
like. Is that the trailer you're
Yes,
talking about?
yes, sir.
Okay, so then it becomes more clear. On page 2, it says the careful movers on it. That's what you're referring to?
Yes, sir.
And then on page 3 and 4, I see a big red. And that's the issue for this case, correct?
Correct.
And so in the code section 3320, which this is my first time reviewing it, I want to make sure I understand. So it says that trucks as defined by this LDC shall be allowed as a conditional use, subject to the following criteria. And I guess, is it the county's position that this is a detachable trailer or semi-trailer?
There's a truck definition in the definition section. It's based on weight.
I'm sorry, can you repeat
It's
that?
based on the weight
Based on the weight.
of the vehicle. This is rural residential mobile homes allowed, so you're citing the correct section. It's about 1/3 of an acre, so they don't meet the 5 acres to even apply for a conditional
So
use.
it'll never be allowed as a conditional use because it's not big enough.
Correct.
All right, so let me look at the definition of truck. 'Cause I want to be on the same page, and I have seen this definition before. Do you have an idea where I can find it? Is it chapter 1?
Chapter 1
Yeah.
definition. Yeah, there you go. Alphabetical.
Sorry, Mr. Linden. I just like to know what's going on before I get
That's
to
great. If you wouldn't mind, I'd love to have a copy of that because this
I-
way I know what,
I think it's online.
It is. It's on their website.
Yeah. Let me see. Truck. Any motor vehicle designed, used, or maintained primarily for the transportation of property and having a gross vehicle weight of 10,000 pounds or more, as used herein, the term shall not mean a recreational vehicle. Are you saying, is it the county's position that this red trailer weighs 10,000 pounds or more?
Yes.
How do you know?
I mean, you can Google the weight of the average
I don't know what that is,
semi-detached
though.
semi-trailer. I mean,
I don't think I can pick it up by myself.
You can.
But, Mr. Linden, so what's going on the property?
okay. So, just so we're clear, it doesn't even weigh 10,000 pounds. I have a title to that trailer, and the weight of that trailer is 9,600 pounds. That is the weight of the trailer. So, it's not even over 10,000 pounds. That's one. But two is, when I bought this property, it was during COVID, okay? So, they weren't issuing permits. I was told, yeah, go ahead, you could do this, you could do that. Well, I started doing it, then I got red tagged. Oh, you need a permit. And it was Timothy Green was the building inspector. And I've talked with this man so many times, well, now he's retired. So I'm trying to meet with Carl Jones, but in that trailer is every window, every tub, the sinks, the kitchen cabinets, everything to the trailer to finish building the trailer, okay? So I said to Mr. Green, what do I have to do? And he said, nothing. He says, you're working on the building, everything's in there, you're good to go. Then I got this stuff in the mail. Thank God the mailman knows I don't live there, because I don't live there. I live around the corner in another house on that same block. I spoke with him on the phone, and he says, you have to get a permit for that to be there. Well, it's not staying there. It's being used to store the building products to build a home. It's like, you know, but it doesn't even weigh over 10,000 pounds. I don't want a permit for it because I don't want to leave it there. I don't want to look at that thing. But until I get this resolved with the county as far as they want my property reappraised now because I'm spending more money. I mean, this is a big thing going on. It's not a trailer. You know what I mean? But I'll give you the title to it. I'll go home and get it. That thing does not weigh 10,000 pounds.
You said it weighs 9,600 pounds.
9,600 pounds. But it's not, you know, and everything I got says trucks. That's not a truck, it's a trailer.
Well, sometimes these are defined as trucks under the code.
All right, well, it's a trailer, sir. You know. But I mean, the thing here is it's got everything to build a house. So once I get resolved with the permit issue on the house so I can finish it, that's gonna be going faster than, you know, anything else.
I'm trying to look up and see if there's an easy way to verify the weight of it.
There's also a statutory definition of truck.
Is that
Says 5,000 pounds.
is that relevant for the, well, I mean, B says trucks as defined by this LDC.
I mean, it's not staying there, that's the thing.
Well, no, I mean, that's good because the county's saying it's a violation.
Yeah, yeah. I mean,
Let me ask you this, like, can I ask the county, who's Timothy Green? Do you know who Timothy Green is?
Yes, he was former employee. He's no longer with the county anymore.
Okay.
He retired.
Do you have any reason to believe that what he said about his interaction with Timothy Green is incorrect? You don't know?
I don't know.
Who's Carl Jones?
That's the building director.
And do you know if he has been consulted on this?
No, I'm not
All right.
aware of it.
Josh was out at my house. He's the building inspector now. Him and I met out the property. And this is where I say to you that he wants me to have the property reassessed to change the building permit. So, I mean, he was there and we even spoke about the trail because I moved the carport from the back to the front and he said, Scott, now you can't even put the roof on. I go,
Sir, is
"What?"
that your phone or
Yeah.
do you mind?
All right. It was,
All right, thanks.
but-
So here's my issue. I think what the county's saying, and correct me if I'm wrong, is that if the truck is removed, that will abate the violation.
Correct.
Okay. Mr. Linden, how long do you intend on keeping the truck there? Let's call it a truck just for the purpose of
All right,
conversation.
till I get done building my house. I mean, like I said, the kitchen cabinets.
Why
in
haven't
there,
you
the
received the permit yet?
I have the permit, so
Oh.
I already had the permit, I had to get engineered drawings, we did all this, then the permit got denied because of the way it was worded, so now we're in the process of, like I said, they want me to get the property reappraised to determine whether or not it's gonna be considered a rebuild or a remodel. So, and that's where we're at now, you know what I mean, so.
Mr. Charlton, so
Yeah,
I heard that he applied for it on March 18th.
Correct.
Is your
And
testimony.
as of yesterday, checking it hasn't been issued or approved.
Okay. And do you know if the permit is issued that would remedy the violation or not?
No, not for
The truck.
trucks. No, sir.
nothing's
I'll be
gonna-
honest with you. My concern is the weight and the application here. You've testified that it exceeds 10,000 pounds, but I don't know your basis for that. I just don't know. I do have testimony on the other side saying that it weighs 9,600 pounds. That seems like credible testimony to me.
Except you Google it really quickly and.
I'm trying to Google it.
Yeah,
I mean, help
I
me.
did, and I got stuff right away, and that's crazy. It says.
How would I find this out?
I
by
literally
Googling?
just weight of semi-trailer was my Google, and empty weighs about 35,000. And then they have another one that says, well, it might be 25,000, but it certainly is more than that. It was not intended to, he's got stuff in it too, so obviously that would affect the weight, but this was not intended to. The definition of trucks was meant to keep out RVs and keep out little vans and the small little things people have. And semis, this is clearly a semi. I don't know why it would weigh so
it may
light.
be that what you're saying is correct because I saw a page that says 9,600 pounds might be the capacity, the carrying capacity of a typical.
24 tons, Your Honor.
24
I hold
tons?
a commercial license.
Yeah.
I could tell you what a truck weighs, what you're allowed to put in it,
Okay.
what an empty weight of a vehicle is. That's what the tractor and the trailer combination.
Okay.
Trailers, a regular flatbed weighs about 8,700 pounds. That's a flatbed. A moving van empty like that is about 9,000 to 10,000. Some are 15,000, depending on the size, the weight, the length, everything else. I have a title that will show you that thing don't even weigh 10,000, but that's not even the issue. I don't want it there no more than they do.
It is the issue.
Well,
I'm telling you, it's the
I'm
issue.
just saying the way. Right, you're saying.
Because here's why it's the issue.
Go ahead.
Because if it does weigh 10,000 pounds or more, you're in violation.
It doesn't.
You're in violation if it does.
Okay.
And so that's why it's the issue. If it doesn't, then this is not an appropriate code section to bring, but I suspect that there are other code sections that they could bring where this would violate as well.
Right.
So, I mean, would that be accurate? I don't know.
Can I see the notice of violation?
Yeah, let me see the.
I mean, if that's true, any truck over 10,000 pounds, every pickup truck over 3,500 pounds, the gross vehicle weight is over 10,000 pounds.
Okay, this says that, it does say trucks parked, but it says remove any commercial vehicles parked on the property. And the code section that is cited,
Section B, noted that trailer.
the code second, they cite the land development code rather than, but on the today's hearing, it's referenced as section 20-41 of the ordinances.
I don't. No. That's another case.
Oh, okay.
Yeah.
There's multiple.
There's
on
three
this,
cases
yeah.
on
Well, I
this.
thought this was 22160633.
No,
Uh-uh.
809.
809.
All
Yeah.
right. That answers that.
That answers that.
Right.
Thanks.
Now to talk about
But under the
his
statute,
commercial,
truck is less
right.
than 10,000.
To talk about stuff about his storing his items there for future construction. I mean, you can permit a shed or something to put it in, but a vehicle like this, which he's talked about a title, that's not the right thing. If you remove this, we're good. If he wants to get something to store all the stuff he's going to build in the future, sure, nobody's going to fault him that, because he's obviously trying to get his permit.
I had a permit. I already had a permit.
Well-
Actually,
Hasn't been issued
so-
yet, but it obviously it's in process. Not disputing.
No,
that.
I had a permit.
When did you have a permit?
When they made me get engineered drawings, I got the permit, but
But
that building, that trailer's not on
do
it.
you know the approximate date or
Oh my God.
year? I mean,
last year.
last year,
Last year.
2021.
Yes, and then I got the permit to do everything. I got the engineered drawings, and then it was denied.
Okay.
So then they turned around and said, well, now you got to do this,
Well,
and this.
what that sounds like to me is you didn't get a permit. But I mean, is that, am I wrong?
He's applied for a permit. He has a permit number. He's in the system.
Okay,
So
all right.
I think that's what's confusing.
Okay.
I mean, and that thing's gone as soon as I could get all the stuff out
Well,
of it.
Mr. Lennon, you have two other cases here today.
Yeah, for debris, which is cleaned up.
Hold on a second, sir, if you don't mind. I'm concerned that I'm not able to make a finding that this fits the definition of truck. It may be that the county's right, it may be that you're right, so, the county's adamant that it somehow, that it does weigh more,
Well,
but I don't have any
I
evidence.
have proof it don't, so I mean.
I have no evidence, so I
I mean, I could, but that, I could show them it don't weigh that, but that's still, I don't want
I
it
may
to.
want to see that. So what I may do is, what I'm thinking about doing is continuing the hearing, and if you're able to provide evidence next month that it
could
does
run
weigh
home to
less,
Sassy and get
hold
it
on,
right
that it
now.
does weigh less than 10,000 pounds, how fast will it take you to go and come back?
Half an hour?
If we can continue it and.
Okay,
and-
then what I'll do is I'm going to continue the hearing to next month.
Okay.
All right.
Yep.
I'm not going to find that there's a violation at this time. I'm concerned that you might be right about the definition, and so what I'm hoping for at the next hearing is to, if we have to have this brought up at the next month, then I need to see the evidence of what it weighs.
Yeah, no problem.
Okay. Now, in the meantime, what I would encourage you to do is, if that evidence does exist, go to the county and show it to the county, because they now understand what my concern is.
Okay.
I suspect they won't bring the case back if you're right.
No, they will. They
Well,
don't want
we'll
that
see.
trailer there.
Well, we'll see. So this case is at 216-0809 is continued to the next month. All right.
Wait, before you do that, what about that's that one. What about the other two?
I've already done it, so
Oh.
we'll see. All right. So that's one case.
Oh, that's just that case. We didn't do all three.
We haven't done them yet,
Yes.
and I don't know. I suspect they'll be next, but
The next case on the agenda,
Okay.
Scott Linden, case number 216-0635, Code Officer J.C. Charlton, page 12 of your agenda.
all right.
J.C. Charlton, Citrus County Code Compliance Officer, case numbers 2160633, 2160635, unlicensed and inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41, and accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Code of Ordinances. The address is 989 North Amelia Earhart Point, Crystal River, Florida. Property owner Scott Linden. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Photos taken during my initial inspections on March 17th, 2022. Corrective action inspections on April 19th and April 21st of 2022, and my final inspection on May 17th, 2022. Exhibit B, the notice of violation, notice of hearings, and a copy of the signed certified mail return receipt for both cases.
Same routine, Mr. Linden. I'd like to ask you to look at these documents and let me know if you have any objection to them being evidence.
All right. And if we could we get my address on file here correctly, please? Because if the mailman didn't actually stop me, I never would have got this, and I would have never known there was a hearing. I don't live at that address.
Mr. Linden, they get that address from the property appraiser, so it's your responsibility to change that.
That's the building, but that's my legal address is my mailing address.
No, sir. So anytime there's a violation on a property, what the code allows is for them to mail and provide notice to you with the address that you have put on file with the property appraiser. So what you need to do is, if you want to change that address, please go to the property appraiser and change that address.
Okay. I mean, I'll look at them, but
Please. Take your time.
now, so all these pictures, are we going to final inspection or?
Well, here's what we need to do first is look through them and let me know if you have any objections to them being evidence. So for example, if you have a reason to believe that they're not authentic photos, that they're doctored or fabricated in some way.
Oh, there it is.
What you heard is that there should be several photos in what's proposed as Exhibit A that encompass several different dates. There's some
Yeah.
from April, there's some
Okay.
from yesterday. Do you have any objection to these being
No, I do
evidence? Okay, all right. And we'll talk about them.
All right.
Again, is there anyone from the public who wishes to be heard on this case? Nope. All right. Then without objection, what's been proposed as Exhibits A and B are evidence. I'll take a look at them as you proceed, Mr.
Okay.
Palmer.
I conducted my initial inspection on March 17th, 2022. I observed an unregistered boat in front of the property and an unlicensed and an operable car on the back of the home. I have also observed the property be in violation of junk and debris with scrap metal, discarded items, and scrap wood on the property. A corrective action inspection was conducted on April 19th of 2022, and I observed the boat was registered and the inoperable and unlicensed vehicle had been removed from the property. However, I observed another vehicle in front of the property that had been added there that was inoperable with the front end crushed in the front, covered with the tarp. And I also observed that the property was still in violation of junk and debris with a couch in the back of it, tires, and scrap wood on the back of the property. As of my final inspection on May 17th of 2022, the property remains in violation with the inoperable vehicle in front of the property and the junk and debris on the back of the property.
So are you presenting both of the remaining cases at the same time?
Yes, sir.
Okay. So for the record, this is case number 216-0633 and 216-0635. And I'm just looking at the photos. These are all listed. Oh, I see. All right.
Yeah,
I got both sets
they're
together.
separated, but then
Yeah,
they got
let me-
mixed up when.
No, that's all right. Let me look at the unlicensed vehicle photos. Okay, all right.
There's no unlicensed vehicles on that property.
Well, let me ask you, first, I want to talk to you, Mr. London, about not the vehicles, but the junkyard condition, so to speak.
Okay.
It does appear that even as of yesterday, there's a bunch of what is called under the code junk. In other words, stuff that's kind of out there, like the furniture, the tires, things like that.
The tires are rim. It's on a rim, and that's a spare tire to my pickup truck. One tire. The couch was just put there because we sit on it when we work. But that's, I mean, if that's in the way, I'll throw it out. It don't matter. I'll put it under the shed. And there is a pile of wood. He's correct. I didn't get rid of that. I didn't burn it. But that's it.
Mr. Charlton, is there only one tire on them?
There's tires you can't see in the shadow from
No, I
the,
can't see them. I mean, that's
there's some underneath the
yeah, Mr. London,
trailer
it looks
as
like
well.
there's multiple tires right under the trailer that don't have rims in them.
No.
I mean, I can see them.
There's no tire that don't have a rim. Every tire that's there has a rim in it.
So you're saying there is more than one tire, but they
well,
but they all have rims.
tire this size for the trailer, but that's not a. I thought he was talking about like a truck tire. No, there's one tire right outside the trailer, and that's for my pickup truck.
I see that.
And then there's one right underneath the nose of the trailer in the front there, and that's a little boat trailer tire.
There's at least two under the trailer, and they don't have rims.
I think they're out. They're gone. Because when it said junk and debris, I wasn't sure what he was talking about, so I picked up almost everything but the wood. I didn't burn it. That's the only thing I didn't burn, which I could
Mr.
burn
Charlton,
that.
on page 10 of Exhibit A, I'm going to try and show it to you. Can you see what I'm showing you?
Yes, sir.
What is that purport to show?
Wood debris
Uh-huh.
and it's like scrap metal. It appears to
Some
be
kind of
right there.
scrap.
Yes, sir.
Mr. Linden, do you see what I'm looking
Can I
at?
come over here?
Yeah,
Oh,
please.
okay, yeah, great.
What's that red?
That's a brush hog.
A brush hog?
Yeah, to my tractor.
Okay.
That's not junk by no means.
Have you had conversations with Mr. Charlton about this case?
No, I talked to him one time about the trailer. He told me I had to get a permit if I wanted to leave it there, and I told him I wasn't leaving it there. I told him I talked to Tim Green when I originally took the place down, and he says, well, you have to talk to land development.
I mean, again, they're also right by the tire with the rim. It looks like there is a,
Inversion table.
what is that called?
It's an inversion table.
Inversion table.
Yeah, that's not junk. I use that thing every day.
You let it get rained on and
Yeah.
use it every day?
Yeah, you just lean back on it. I have a spinal stimulator in my back, and that helps. Every day I use that thing after work, every single day.
And in fact, we spoke over the phone in regards to these violations when I let him know about the trailer also and explained the ordinance for junk and debris, discarded items, anything like that.
Did he explain to you that these aren't discarded items and that he uses
Well,
them?
he stated that everything was taken care of.
Okay.
I did, and I thought, there's no car. Actually, I'm the one who told him there was a Mercedes there.
If
That I had just gotten in an accident, and the Mercedes is gone. The
Mr.
other
Charl-
car is gone.
Mr. Charlton, so if he uses the inversion table every day, does that constitute junk?
It's a household, indoor item, household item that's not, made for the weather, constructed outdoor for the weather. To me, it for the code where it states it's discarded.
And would that also be your response for the red couch or sofa?
Yes, sir, because the materials can hold water, can draw, mosquitoes and.
I'll get rid of the couch. That's not a problem. The inversion table, just like a weight bench. It could be outside. It's metal. So, if you want me to put it under the shed, I will, but it's an out.
I think Mr. Charlton's point is probably correct that, depending on the material, if it's, meaning that we're all in agreement on the couch. You're in agreement, we're in
listen,
agreement.
I just put that there like,
Yeah.
it wasn't there the first time he was there.
For the inversion table,
I could stick it under the yellow shed. That's not a big deal. And take it out when I use it every day.
would that satisfy the county?
Yes, that'll be fine.
And sir, just so you know, that's the backyard. You're looking at the backyard.
Right.
I mean, I could put a big fence up and nobody would see anything, but
Well, I encourage you not to do that as a method of just
I'm
evading
just
the
saying,
county's inspections.
the inversion table I use, it's like having weights outside.
I mean, it
don't
looks
see-
like there's overgrown grass. I don't think you've cited them for that.
No, I mow the grass, so,
It's getting there.
Okay.
I take care of the property, so
All right.
that's why,
So
he
what I'm
talked to
gonna
me
do is
once.
I'm gonna put on the record what does need to be fixed then. We agree on the couch.
Yep, and the wood.
Mr. Charlton, I see some panels and stuff near the boat. Is that subject to the violation?
That was from the initial inspection.
Okay, and it's gone.
Yes, sir, that's been removed.
Okay. I agree about the inversion table. I don't think it's a violation based on the materials. I think it's possible to have that in someone's backyard and to use it. Is there anything else that is still in violation, Mr. Charlton? The wood?
Yes, scrap wood, yes, sir.
Scrap wood. All right, what's the county's recommendation on this case?
For this case, Citrus County Code Compliance Division requests the special master assess a fine of $100 per day along with the administrative costs begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask that the special master find that it is the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
All right, I want to rule on this case before we get to the unlicensed vehicle case. So what I'm going to do, Mr. Linden, is I don't think you need much time at all to address
I'll
this.
throw
So
it in the back of the
what I'll
pickup and
do
go to
is
the dump.
I'm going to find that this property is on case number 2160635, that it's in violation, but I'll grant you 30 days from today to abate the violation, which in this case would be
The couch and the wood.
couch in the wood and any other junk that may be there that's in violation. But I'll make specific findings about the wood and the couch.
Right.
30 days from today to abate that violation. If the violation is not brought in compliance as ordered, in those 30 days, $100 per day
Yeah,
will
it'll
be
be
imposed. This fine will be recorded and will constitute a lien on your real or personal property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And Mr. Linden, you would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. All right, so that'll end that case. Now let's talk about the unlicensed and operable vehicles. So if I understand the county's position, the boat is a violation?
The boat, it was in violation, it was unregistered, but he has gotten it registered and it was removed also.
Okay,
It
so
will be
that's
put
not a,
back though, it's going back.
Right,
It's
and
just being
there's
washed.
no issue with it being there,
Okay.
it's registered now.
okay, so that's not an issue for this case.
Correct.
However, what about the car on page 2, which is kind of an older looking rusted car?
That has been removed as well.
That's done. On page 3, there's the car that you referred to that looks like it's busted in the front.
Yeah, the Mercedes.
Is that still there?
Yes, sir.
Okay.
It is not.
It was there yesterday on my
Okay.
final inspection.
And so it does appear that it was there yesterday.
You can call Smitty's junkyard, it's gone. He
alright.
picked it up, I was waiting on him.
Okay. Was that the only remaining violation?
Yes, sir.
All right, so what I'm going to do, Mr. Linden, is I am going to find that the property is in violation, but it needs to be re-inspected by the county to verify that that Mercedes has been removed from the property, and if
Yeah.
it has, you're not in violation.
It has,
I may
okay.
not even issue an order, okay? So what I'm going to find is that the property is in violation. You're granted 30 days from today to abate the violation. If the violation is not brought in compliance, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests Special Master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the Special Master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
There would be a penalty of $100 per day. If it hasn't been fixed in those 30 days,
Right,
the fine will be recorded and will constitute a lien on your real or personal property.
I gotcha.
I know you do. I have to say it for the record. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and you would be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Alright, how about we put this on the record? I'll meet you whenever you can, and you could walk around the yard and tell me what you want gone, and I'll do it. I mean, it's that simple.
All right.
I'm trying to, I mean, if it wasn't for the building
I think
department,
that's
that
useful.
trailer wouldn't be there.
I think that's useful, and the county may take you up on it, but that's it for this hearing. We've
All right.
resolved it.
Thank you.
All right, thank you,
Does he
sir.
have a business card or something?
I would encourage you to talk to the county after the hearing. We just have some other cases to
So
get
we're
to.
done, right?
Yes, sir.
Next case, owners self-finance, case number 2160100, Code Officer J.C. Charlton. Joanna Catu is the expert. Page 13 of your agenda.
You get to have all the fun, Mr. Charlton.
Yes.
You really do.
Yes, it's Crystal Rivers, the Wild Wild West sometimes.
I love Crystal
Well,
River.
over in my part of the county.
Oh, yes. J.C. Charlton, Citrus County Code Compliance Officer, case number 2160100. Special requirements for all accessory structures in violation of Citrus County Land Development Code 3102A. The address is 5783 West Grove Park Road, Denellen, Florida. The property owner self-finance. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 8th, 2022, corrective action inspection on April 21st, and photos of my final inspection on May 17th, 2022. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the signed certified mail return receipt, and a The property appraiser summary listing the property as vacant.
Is there anyone from the public wishing to be heard on this case? Okay. Without objection, what's been proposed as Exhibits A and B are evidence.
Conducted my initial inspection on March 8th of 2022 and observed a detached semi-trailer and an unlicensed van on the vacant property zone Coastal Lakes Residential. I've had contact with property managers on the property who was maintaining the property, but I've had no contact with owner self-finance. As of my final inspection on May 17th of 2022, the items remain on the vacant property.
You said who did you have contact with?
They stated that they were property managers. They were there cutting the grass because I had a lawn case on the property. And they stated that they would let the owners know about the other violations on the property, and no
Other
one
violations?
the storage on the vacant for this violation.
Oh, just this
were,
violation.
Right, they were there for the lawn case that I had on it.
Oh, I see.
And that
You had a
closed.
separate case.
Yes, sir.
I see.
And that closed prior to.
Oh, okay. I do see that it started looking a lot better. It says Owner Self Finance Inc., I guess care of Brown and Associates Law and Title PA. Do you have any idea who they are?
No, the some
Okay.
bids was
Yeah.
active, so
Okay. Is there anyone else from the county who wishes to testify?
yes.
Joanna Two, Land Development, Coastal Lakes Residential with mobile homes allowed, should be otherwise vacant. No record of permits for development at this time.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation, respondent's actions relative to this violation. We would also ask the special master additionally fine that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of owner's self-finance. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Are you guys still bringing the case against the United States of America?
The one that was continued.
Oh, it is on the agenda,
Yeah,
okay.
it's on the
Wow.
bottom.
Yeah, we can.
Do you wanna do that?
Oh, whatever the county prefers, I don't decide.
Yeah, Joanna's done. She knows that.
It was just on my mind.
Next case, United States of America. Case number 216-0481. Officer assigned to the case, Amy Becker. Page 18 of your agenda.
So I think we can just incorporate the record from the prior hearing. Is the county have a position on whether or not it can proceed against the United States of America?
I was researching it, and I'm suspecting there's some sovereign immunity issue in there. However, I came across the Florida part of the sovereign immunity, and it said if there's a statute that says the property can't be liened, and I didn't get an opportunity to find out if there's a federal law that says federal property can't be liened. So that's where I was.
It's progress. I'm still concerned. I think that if the county had the ability, well, look, it may be possible that the county has the authority to place a lien but not enforce it.
That was what I was going to request that you can go ahead and consider the case, issue your order, and then if there's an inability to enforce it or foreclose on it, the property may change hands in the meantime anyway. Because it was a mortgage that was foreclosed, and the property then was purchased by the United States.
I'm just thinking about it. Such a lien would conceivably run with the land regardless of who owned it. So it may be that while it's not enforceable against the United States, it could end up being paid down the line. I'm a little concerned that, for example, in olden times, that if the United States of America could have been leaned upon in certain parts of the country, that it would have been. And I think that laws evolved to probably prevent that. And I'm not just talking the supremacy clause, but from 1865 to onward, I think that states and local governments would have had an incentive to do that, and I don't recall them ever getting away with it. So it's kind of why I'm hesitant to do it. But the property is in violation, and I hate to do this to you. I'm going to continue it again. I'd really like to know if I have authority to do it. I'm hesitant to put the county in a position where it's adversarial to the federal government. So would a continuance of 1 month be enough? Is there?
I hope so.
Okay, all right. Then I'll continue it to the next
Depends
hearing.
on what comes
Thank
up
you.
between-
I get it. Yeah, I understand. Thank you.
Next case is Michael Allen and Karen Gross, case numbers 215-8816 and 215-8817, pages 6 and 7 of your agenda. Code Officer George Pearson.
You could always have been doing push-ups back there. I won't hold it against you.
I stood up once in a while.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. I'm going to present both of these cases as one.
Thank you.
For the record, my name is George Pearson. I'm a Citrus County Code Compliance Officer. Case number is 215-8816. Junkyard conditions, a violation of Citrus County Code of Ordinance, Chapter 20, Article 3, Section 20-31A, and case number 215-8817, Overgrown, Unkept lawn, violation of Citrus County Ordinance, Chapter 20, Article 6, Section 20-61. The address of the property is 4688 East Bow and Arrow Loop, Inverness, Florida, 34452. The property owners are
The Grosses.
yeah. Let me get the Michael Allen and Karen Gross. The service was good through posting of the property and posting of the bulletin board dedicated to such postings at the Lecanto Government Center. And I'd like to authenticate and request the following be entered into evidence. Photographs that I took on February 10th, 2022, the photographs depict the violation of junkyard conditions and overgrown unkept lawn. Exhibit B, copies of notice of violation, notice of hearing, and affidavit of posting. Exhibit C, I took photographs on May 17, 2022. The photographs depict the property to still be in violation of junkyard conditions and overgrown unkept lawn.
Are these the exhibits for both cases?
Which that's
Are there, is Exhibit A, B, and C, are these for both cases? Or
yeah, no, they're separate A, B,
Okay,
and C.
all right.
And the case number is at the bottom.
I got you. Is there anyone from the public who's going to want to be heard on either of these cases? Let the record reflect that there is no response.
Surely you joke.
No, I create a record. Sometimes the record is a joke, but so far I don't think I've been successfully appealed. But maybe I have been, I don't know.
I don't think so.
If I'm wrong, I'm wrong, you know. There's no pride in it. It's one just wants to be right. And I know that the excellent Citrus County judiciary will find out if I'm wrong. They'll figure it out.
Definitely.
We're very lucky with a good judiciary here. What's been proposed as exhibits A through C in both cases is admitted.
Okay. I think I'm not sure. Okay. I conducted an inspection on February 10th, 2022. I observed a violation of junkyard conditions and overgrown unkept lawn. Junk and debris was observed at different locations on the property. A violation of overgrown unkept lawn was observed with grass and weeds in excess of 18 inches. The residence appears to be vacant. No contact has been made with any property owners. The notice of violation was issued on March 11th, 2022. Notice of hearing was issued on April 14th, 2022. Final inspection was conducted on May 17th, 22, and a violation of junkyard conditions and overgrown unkept lawn still exists.
Have you had contact with the property owner?
No, I haven't. But the odd thing is, when I notify them of the violation, by putting a violation sticker up there, which is like a door hanger, and when I posted the property, both of those were removed. So but they've not contacted me, nor have I've never received any contact.
Is there a door on that porch that you took the photos of?
Yes.
Is the material inside that porch?
Some of it.
Well, is that part of the violation?
It's part of the photographs. I don't know if it would be.
Well, I just want to make a clean record, so for example, what I'm concerned with is that all the junk that appears to be in the porch may be in an enclosed building.
Yeah.
Okay. So, it looks terrible, but I don't know if that's a part of the violation. There's plenty of other stuff that does violate in your photos.
No, that's not a part of violation,
Okay,
but there's no way you can get the photographs of the other violations.
Okay, fair enough. And then on the, grass in excess of 18 inches case, let me take a look at those photos. All right, what's the county's proposed recommendation?
Citrus County Code Compliance Division respectfully request that the special master assess a fine of $10 per day per violation along with the administrative cost to begin after the date you deem sufficient to abate these violations. The amount was selected based on the actions of the property owners once they were advised of the violations. The amount is appropriate given to the severity of the violations and the respondent's actions relative to the violations. We would also ask that the special master define that that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I just want to make sure I heard you right, because I've never heard the county recommend that before. $10 per day?
No, 50.
Okay, all right.
No, 50 per
That's what
violation.
Gotcha,
I'm sorry.
thank you. All right, that makes
Did I
sense.
say 10?
You did.
I'm old. I still sweet and low.
All right, so in each case, I find that the property is in violation. In each case, the owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. That goes for each case. This fine will be recorded and will constitute a lien on the real or personal property of the Grosses. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the Grosses shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Have you ever been to Pearson, Florida?
Yes. You know, there's a famous baseball player who used to play for
Chipper Jones.
Yeah, Chipper Jones.
Yeah,
He's from
he
there.
is Pearson's.
I almost joined the police. I almost was the chief of police at Pearson, Florida.
No
'cause
kidding.
My name. No, I'm kidding.
Oh. I was going to say they've abolished their police department,
No,
so
I
that
know,
would be
I
very
know.
surprising to me.
But there's Lake Barbara, which is my wife's name, not far from it too.
No kidding.
So, yeah, they're the fern capital of the world.
I'm the town attorney for Pearson, so it's I'm there very often. Yeah.
What's Chipper up to?
Well, I don't know if he's still there, but they named the baseball fields after him. And
He was
so,
a high school athlete there
Yeah,
also.
he was a
like
star there.
Football player, everything.
Oh yeah. Oh yeah. All right.
Next case, Jeffrey B. Harrington, case number 215-8145. Code officer on the case, George Pearson, page 8 of your agenda.
Ready to go, Mr. Pearson?
What are you saying over there that's funny about me?
No,
Please don't make fun of me, man.
We're talking about mints.
Okay.
I wouldn't do that, George.
Okay, my name is George Pearson. I'm a Citrus County Code Compliance Officer. The case number is 215-8145. The violation is junkyard conditions. A violation of Citrus County Code of Ordinance, Chapter 20, Article 3, Section 20-31A. The address is 12142 East Supreme Court, Floral City, Florida 34436. Property owners Jeffrey B. Harrington. Services good by posting of the property and by posting of the bulletin board dedicated to such postings at the Lacando Government Center. Exhibit A, photographs that I took on February 21st, 2022. The photographs depict the violation of junkyard conditions. Exhibit B, copies of the notice of violation, notice of hearing, and affidavit of posting. Exhibit C, photographs that I took on May 17th. The photographs depict the property still to be in violation of junkyard conditions.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no one.
Fence is gonna fall over, what do you think?
Yeah, that's part of it, you know, just jumping all the stuff around it and some of the things you can see inside.
Do you have an A, B, and C on this one? Exhibit?
Yeah, of course I do.
Okay. Then
I'm
what's,
the only one, right?
so
You
far as
know
I
why?
know.
Because I was taught right. I wasn't taught to do it easy. Why
I hear you.
You teaching everybody the easy way. No, I'm not criticizing. I was just taught before and after.
I like both ways. All right, so what's been proposed as exhibits A, B, and C are evidence.
Yes.
Cool.
I conducted an inspection on February 1st, 2022. I observed a violation of junkyard conditions. I spoke with the property owner, Jeffrey B Harrington. He was advised of the violation and stated he would resolve it. A notice of violation was issued on March the 3rd, 2022. A notice of hearing was issued on April 7th, 2022. The final inspection was conducted on May 17, 2022, and the violation of junkyard conditions still exists.
So what's the violation as it stands today? I'm looking at the photos.
Well, it's the old wood fence that's not consistent with building fence materials, and occasionally you can see through the fence and see tires back in there. I think he put up the fence as a barrier for me seeing the violations back there.
So it's the county's contention, I see the photo of the tires.
Right.
It's the county's contention that there remains a violation beyond the fence, but also that the fence itself is a violation.
Well, the fence is a violation, sir,
Okay.
because there's wood stacked up that's not in place, and there's pieces of plywood and tarps over the fence. Now, I have, Mr. Harrington is odd in that he wouldn't come outside to speak with me at first, and when he eventually did, but then when I posted his property and subsequently notified him of notice of violations and stuff like that, he has never contacted me and tried to rectify this problem.
I'm just going ahead and there's no doubt there's a violation. I'm just reading the definitions. Yeah, I mean, I think that the debris of the fence does satisfy the section as well, so it appears that the situation has gotten even worse since you started the case.
Yeah, and if the fence was not there, who knows what would be behind it.
What's the county's recommendation?
If I say $10 again, would you let me know?
Oh, I will.
Okay. The Citrus County Code of Compliance respectfully requests that the special master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. The amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Just for the record, it's totally within the county's purview to recommend $10 a day or $1 a day if it wants. I probably wouldn't adopt it just because of maintaining consistency with prior rulings.
No,
just so you know.
in all seriousness.
No, I'm just putting, I understand. I just want you to know. I'm not offended by it. I probably wouldn't follow it. Now, I am going to deviate from the county's proposed findings. I am going to find that the property is in violation and adopt the proposed findings of fact. But I'm going to grant the property owner 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. I think that there's an aggravating circumstance here, which is this fence, which is designed to evade responsibility for the violation that you established. It doesn't seem like it was done in good faith, and it actually constitutes a furthering of the violation. Therefore, this fine would be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And Mr. Harrington shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
Thank you, sir.
Next case, Edgar Allen Jacobs and Tricia D. Harmon. Case number 2157171, Code Officer George Pearson, page 9 of your agenda.
Please proceed.
For the record, my name is George Pearson. I'm Citrus County Code Compliance Officer. The case number involving this violation is 2157171, junkyard conditions, a violation of Citrus County Code Compliance Ordinance, Chapter 20, Article 3, Section 20-31. The address is 8240 South Lake, Consuela Drive, Floral City, Florida, 34436. The property owners' names are Edward Allen Jacobs and Teresa D. Heron, P.O. Box 3044, Seminole, Florida, 33775. Service was made good by posting of the prop.
Hold on a second. What was the address?
The address was P.O. Box 30.
Oh, the mailing address.
Yes.
Okay, I'm sorry. The violation address is 8240 South Lake Consuela Drive, right?
Yes.
Okay, all right, thanks, sorry.
I'm sorry. The service was made good by posting the property and posting in the bulletin board copies of the violation, a notice of hearing rather, dedicated to such postings at the Lecanto Government Center. I'd like to authenticate and request the following be entered into evidence. The photographs that I took on January 12, 2022, the photographs depict the violation of junkyard conditions. Exhibit B, copies of notice of violation, notice of hearing, and affidavit of posting. Exhibit C, photographs that I took on May 17th, photographs the property depicts the property to still be in violation of junkyard conditions.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no response.
I'm just going through everything right now for the afternoon or the morning? Yes.
All right, what's been proposed as exhibits A, B, and C are evidence?
I conducted an inspection on January 12, 2022. I observed a violation of junkyard conditions scattered throughout the property. A notice of violation was issued on March the 11th, 2022. A notice of hearing was issued on April 22nd, 2022. I spoke with the property owner, Tricia D. Harmon, who advised that she would see that the property was resolved, that the violation was resolved. The final inspection, however, was conducted on May 17th, and the violation of junkyard conditions still exists.
Has there been improvement?
Yes, sir. As a matter of fact, she was there at the time and spoke with me, but she had a long weekend to resolve it, and there wasn't anything that she couldn't get resolved.
I mean, it looks to me like there's been a lot of improvement. I just want to make sure, looking at your exhibit C, what remains of the violation. It looks like there's some vegetative matter, debris.
Yes, and tires over there on the left-hand side.
Oh, I see. Okay.
And miscellaneous junk and debris.
Okay, what's the county's recommendation?
The Citrus County Code of Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. The amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found in violation. Property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you very much,
Thank you.
Mr. Wall.
Last case on the agenda, Rodney R. Blake, case number 215-5852. Code officer on the case, J.C. Charlton, page 4 of your agenda. J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-5852, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This case was continued at the March 18th hearing until the April 20th hearing, and another continuance was also granted on April 14th until today's hearing. The address is 7488 West Cowhide Cove Path, Crystal River, Florida. Property owner Rodney R. Blake. I would like to authenticate the following documents and request they be admitted into evidence. Photos taken at my pre-hearing inspection on May 17th, 2022. Exhibit B, a copy of the notice of violation, notice of hearing, the continuance letters, and a copy of the email requesting a continuance for today's hearing.
Did we admit the photos before in prior hearings?
I think we did.
They were admitted, yes, but you didn't
I can-
issue a finding.
Do you want me to do that?
Well, I want to make sure that we incorporate that
Okay.
because it doesn't sound like you're putting it into the record today, the prior stuff.
Right, okay, you're right. Did you
Okay.
want that in, or? is-
Well, yeah, if it's been admitted, I want it in. No, so, I mean, let's look at the exhibits you've got, and
Okay.
then we'll go from there.
All right, no
Is there anyone from the public who wishes to be heard on this case? Nope. Then without objection, what's been proposed as exhibits A and B will be evidence. All right, let's see. Are the photos that are in Exhibit A substantially the same as those in prior photographic exhibits in this case?
Yes, sir. There's been a little change. She did email some photos of a roll-off dumpster with some items in it, but it was very, very little change as of my final inspection on May 17th.
I guess I'm just trying to establish that it has been in violation for the last several months.
Yes, sir.
Do you know, have they told you how much time they think they need?
No, actually the last contact I had was April 14th, and I've attempted to call and, find out if they've made any progress, and I went out yesterday and the road's serviceable, so able to access the road to go do the inspection, but no contact has been made.
According to Amy Blake, email address eviljungleprincess@yahoo.com on April 13th, 2022. The tenants have been evicted. The property has been secured with fencing. Doesn't sound like the owner of the property is in a condition to actually perform the cleanup himself. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $200 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Find that the property is in violation. The property owner is granted, because it's a higher fine amount, I'll allow 90 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on the real personal property of Rodney Blake. An additional reason for the extended time is what appears to be the medical condition of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Thanks. The time is 11:04, and this hearing is adjourned.